We are on the record for the hearing in the matter listed in the North Dakota Industrial Commission hearing docket for Tuesday, October 25th, 2022. I'm Stephen Nelson, the hearing examiner for this hearing. We are in the hearing room with the Department of Mineral Resources, Oil and Gas Division, and it is 9:02 a.m. Today's hearing is case number 29290, an application of Gary Hagan for an order to determine the actual costs and proper payout statements, interest due on working interest payments made more than 150 days after sales, enforcement of cost-free royalty statute, and other forced pooling issues related to unleased mineral interest in certain oil wells operated by Whiting Oil and Gas Corp. in a spacing unit described as sections 1 and 12, Township 153 North, Range 98 West, sections 6 and 7, Township 153 North, Range 97 West, Banksfield, McKenzie County, ND, pursuant to NDCC Section 380808 and NDCC Section 471639.1, and request for a hearing pursuant to NDAC Section 43020388. Will all interested parties please come forward? And Mr. Hagan, to begin, we'll have you state your name and address for the record, and we'll let Mr. Mann make his appearance, and then you'll begin your case.
His name is Gary Hagan, 514 America's Way, number 9833, Box Elder, South Dakota, 57719.
And Mr. Mann?
Thank you, Mr. Examiner. Wade Mann, P.O. Box 2798, Bismarck, North Dakota, appearing on behalf of Whiting Oil and Gas Corp.
And Mr. Hagan, it is your case, so you may begin.
Thank you, Mr. Examiner. To begin with on my presentation today, I'd like to just go over some of the facts of the case from the application letter. Some of the items have changed in the last 7 months. I'll do a quick review on those, and then I'll go into my exhibits. As I said in my application letter, my family privately owns 80 acres of unleased mineral rights in the Banksfield, McKenzie County, North Dakota. We are unleased, non-consenting joint tenants in 15 wells operated by Whiting Oil and Gas. None of us have ever signed any AFEs, joint operating agreements, or other documents agreeing to any legal obligations with Whiting. We were force pooled by the NDIC in August 3rd, 2015. And the first well in this drilling unit was drilled and completed in 2016, followed by 14 more wells in 2018. First production was in July 2018 on those wells. Some of the issues I want to talk about today are the well payout schedules, some of the accounting practices that Whiting employs when they determine these payout schedules, and computation of proper payouts and post-production costs and other items. In the exhibit package that I gave you, it's the tabs are color coded. The A exhibits are on top. Those are the ones I'll be starting with first. B exhibits are in the yellow tab. The red tab is the North Dakota statutes, NDCC 380808 and NDCC 1639.1, and the D tab is my concluding arguments and a list of items that I am seeking the NDIC to make a ruling on today.
And Mr. Hagan, are you intending on giving testimony today?
Yes.
So before you give any testimony, I should swear you in first so we can.
Oh, okay.
So please raise your right hand. Do you solemnly swear or affirm under the penalties of perjury that the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
Yes, I do. So there's a lot to cover in the case, and although there are 15 wells in this drilling and spacing unit, for the sake of brevity today, I'm going to focus mainly on the first well that paid out, which is the Wold Federal 447-4XH. And I'll touch briefly on two of the other wells, the Wold Federal 7H and the 5XH, because there are non-payment of royalty issues with both of those wells. And providing telephonic testimony today will be my CPA and expert witness, Mary Ellen Denemy, who is an accredited petroleum accountant and all of her credentials are on file, and her statements are on file with the NDIC already. Some of the exhibits have been modified since my original hearing application in March 2022, but all of the wells have the same issues. And so when we talk about the Wold, I'll just refer to the Wold Federal 44-7 4XH as the Wold 4XH, so I don't have to say that out every time. And I'd like to talk for a second about what it means when the NDIC force pools and unitizes you, what it means to a mineral owner, what your options are in that case. You've got four basic options. You can either sign, if you're unleased at the time that the AFEs come out and everything, you can either sign the lease that the oil company offers you and just take whatever they're offering in the way of a bonus payments and royalty. Or you can participate in the well if you have the money to do that. This is their second option. But these wells cost between, my share of each of these wells would have cost $30,000 to $40,000 without the risk penalty. So that's pretty much out of the question if you're a mineral owner, unless you've already got a lot of money. The third option is you can sell your mineral rights, but who wants to do that? I mean, some people do, but if you ever want to make any money off of it, you need to keep their mineral rights. And the fourth option is to go non-consent. And when you do that, when you choose to go non-consent, the oil company or somebody else they're working with, in this case it was Whiting, assumes your share of the costs of drilling and completing the well. They carry carried interest in the well, and they are entitled to use your royalties from production to pay down your share of the costs in that well, plus a 50% risk penalty that the state of North Dakota mandates by statute. And that's what they get for their share of drilling that well. When your share of the cost and the risk penalty are paid out, are paid off, that's called payout. And at that time, the mineral owner, me in this case, owns your share of the working interest in that well. So I'm not just a mineral owner and a royalty receiver. I'm a partner with Whiting at that time. I own that working interest in the well from then on once it's paid out. And so far there are 6 of these 15 wells are known to be paid out, and there's 2 more that are probables that have happened in the last 7 months that I don't know what Whiting's, I know what their payout statement says, but I don't believe it's correct. So so we're talking about 8 wells more or less that I own my working interest in, and the rest are still being carried by Whiting and being paid off. Now, my actual cost in these wells has been affected directly by several factors that are subjects of the hearing today that I'm going to get to in my exhibits and talk about. Well, I'll get to that in a moment. I want to start with my exhibits, I think. Just a moment, let me check my notes here. Okay, I think I can go into Exhibit A1. Is that ready for that? Okay. So my first exhibit in the folder there is a chart I made called the components of an unleased mineral interest. My interest in this well is, in this drilling unit rather, is 11.4028 acres. And when you compute that the entire drilling unit is 2,546.57 acres. So my share, 11 acres of that drilling unit, amounts to .0044777 of the total interest in that drilling unit. And that interest is broken down into two parts. First, I have my statutory royalty interest of 16%, which is, again, is mandated by North Dakota statute. And I've listed the decimal interest for that statutory royalty interest. And this matches what's on my revenue statements that I get from Whiting, is .000716437 of the drilling unit. So the 16% is a royalty interest that they've been paying to me since the wells began to produce. The other 84% of my total unleased mineral interest is the part that that is now my working interest that I own on some of these wells. And the decimal interest for that is listed below it as well, as .0037613. And I'd like to avoid confusion, I'd like to point out that the number 16% occurs in two different contexts when we're talking about my unleased mineral interest in these wells. First, you have the 16% statutory royalty interest that we get paid. And then as part of the expensing for paying off my share of the wells, there's an item called a royalty burden. And Whiting computes that as being 16%. But it's two different things. The royalty burden is not the same thing as my statutory royalty interest. The statutory royalty interest is a fraction that's based on my decimal interest for the acres I own. But when Whiting computes this royalty burden, they're charging off 16% of all of the revenues for the entire drilling unit to me as a cost. And I don't believe that that's correct, and my expert witness will address that more. But that's one of the central issues that I have to talk about that today, is that I do not believe that they are computing this royalty burden correctly. And I've given an example of how they compute the burden. They take all the gross revenues for oil, NGLs, gas, condensate for the entire spacing unit. They deduct taxes and post-production fees, and then they multiply that times 16%. And a couple of exhibits from now, I will walk you through that and show the math on how they do that. So, for example, if you had $10,000 in net revenues for any one of these given wells, Whiting would be charging me $1,600 against payout on the royalty burden, but they only pay me $7.16 for my 16% statutory royalty interest. And one other comment I should make about these decimal interests that I'm showing you right now, I have adjusted these they changed last spring as a result of the KLJ study from the ordinary high water mark case. I'm sure you're all familiar with that. And Whiting reversed and rebooked all these revenues according to these KLJ adjustments. That has already been done. So although all of our family interest in these acres is above the high water mark, there are other parcels in this drilling unit that were adjusted by KLJ as a result of the high water mark case. And so they reduced the size of the spacing unit by about a little over 2 acres, and they reduced our our acreage unit, went from exactly 80 acres down to, they took off 1/1800ths of an acre, so it would be 79.82 acres is what's left, and that is the number of acres that I used for these computations. I changed this exhibit since March for that reason. Just a moment, let me find the exhibit. So here we go. Okay. So one of the things that, in my correspondence with Whiting about this matter, they tend to think of, when we talk about an unleased mineral interest, it means all of my interest in the whole drilling and spacing unit. But when Whiting looks at it, they like to think that the unleased mineral interest is only the statutory royalty interest. And that, therefore, that is a reason why they don't have to comply with some of these statutes, why they don't have to pay royalties, and why they don't have to pay interest on unpaid royalties and things like that. That's all I had to say about Exhibit A1. I have a question for the hearing examiner. After each one of these exhibits, am I required to request that it be admitted to the record, or do I wait until the end and just do them all?
However you prefer, we could do it one by one, or if you just want to do it all as one package. I guess, Mr. Mann, do you have any preference or objection to?
However you want to do it, Mr. Examiner, I'm fine. I don't have an objection to the first exhibit per se. I don't think it's correct, but that's something that can be addressed, through cross-examinations.
So why don't we just do it each exhibit, then have you offer each one, and then we can.
Okay, I'll offer this Exhibit A1 to be admitted into the record then.
The exhibit is admitted.
Okay, the next exhibit, A2. This is a original payout statement that I received from Whiting in September 2020. Although this well was supposed to have paid, according to Whiting, paid out in September 2019, a year earlier, I was not provided with these statements until I started asking questions in June of 2020, and it took another several months after that. And as I mentioned in my hearing application letter, nothing happened for months after I originally requested information about these payouts until I called the NDIC, and the very next day Whiting sent me these statements that I had requested for 4 of the wells. So my purpose in submitting this as an exhibit is just to show you the example of the first payout statement that I received from them, and also to prove that I have not altered the revenue and expense numbers in my subsequent exhibits. Normally, this is not what they send you in the way of a payout statement, but their computer system or whatever system they have for keeping track of payouts was broken at the time. They were unable to produce me the regular payout statements, and that continued to be the case until about June of the following year after this. So this statement was made for me by a payout analyst at Whiting, just as a courtesy, because they were unable to produce the regular document. So and just briefly, I'll describe what's on the statement. They list the date and year of the accounting period on the left. The first few columns are revenues: oil revenue, gas revenue, NGL, and taxes. And then the Roy Rev column is the burden that I'm going to be talking about later. The Roy Rev asterisk column. And then when you do the math on those, you deduct the taxes and the expenses, and then you come up with a net revenue number, and that tells you how much, when you multiply my decimal interests times that net revenue number, that's how you determine how much of my revenue is going to go toward the payout on the well for that month. Then the next columns to the right of that are the expenses. The TDC is tangible drilling cost, intangible drilling cost, tangible completion cost, intangible completion cost, workover costs, lease operating expenses, and that's going to be another one of my central arguments, is that these lease operating expenses are incorrect, and Whiting has admitted that both before and during discovery. And SURF is surface equipment. So after they list all these columns, then they tell you what the total expense is, and then in my case, I have a 150% payout because you add in the risk penalty. The 50% statutory risk penalty is added on top of those expenses and applied toward my payout. So I'd like to, I think that's all I have to say about that exhibit, and I'll request that it be admitted to the record.
No objection.
The exhibit is admitted.
So Exhibit A3, Old Federal Forex Revenues and Royalty Burden. This is a spreadsheet that I made up after I got that royalty statement. I started looking at these numbers and comparing them to my revenue statements, and I noticed that the numbers that Whiting was telling me in the payout statements did not match up at all with what was in my revenue statements. So I started digging and trying to figure out what exactly is going on here. So on this exhibit, the columns and cells that are in green are the original numbers from Whiting that were on that Exhibit A2 that I just showed you. And next to that in yellow are the columns that I inserted that have the numbers from my revenue statements. And it goes, this is only the revenue portion here, not the expense portion. And so you can see that the revenues were higher on my revenue statement than what they were saying in payout. And the other thing that comes into play here, the top yellow line for July 2018, line 12, that's highlighted in yellow, that is the original production date of these wells, the date of first sales for these wells marks that. The bottom line, line 26, September 2019, which has green and yellow lines, that is Whiting's computed payout for the well. That's the date that they originally determined that the well paid out. And the coral line, May 2019, that's the date where I think it should have paid out according to my calculations. And so when you, so I started looking at these numbers and thinking, well, look at the gas number. Whiting's gas revenue number is about 5 times less than what was on my than what they were reporting on my revenue statements, and the same is true of NGLs. And I started thinking, well, why is that? Why is that? Because what's going on there? And they wouldn't tell me. Then. And so then I started doing the math, and I've written in column O, R, U, and X. I'll walk you through how they compute this burden pay down next. So they take column B, the gross revenues that they report for oil. Column E, the revenues for gas. Column I, the revenues for NGLs. And they come up with a revenue total. Then they subtract the taxes in column R. That's severance taxes to the state that we're talking about there. And after they come up with their net revenue number, and they multiply that times 16%. So this is all the revenues in the drilling unit we're talking about. These are not my revenues. This is all the gross revenues for the drilling unit. They multiply that times 16%, and they call that the royalty burden. And then they subtract that out too to come up with a net revenue number that will go toward my pay down for the well each month. And it turned out, well, spoiler alert, that the gas and NGL revenues, the reason those numbers are so low is because those are not really gross numbers. They're netted numbers after they take out all these post-production costs that we'll be talking about today too. But I did not, they would not admit that or tell me or show me what the costs were until after I filed for my NDIC hearing in March this year. I did not know. We could make an educated guess with my CPA that that's what they were doing, but we didn't know that for sure. We couldn't prove it. And they weren't volunteering any information about it. So. And I believe I said that so the net revenue number is my net revenue that is available to apply toward the pay down of my share of the costs for this well. And they do this each month until I'm paid out. They continue to take out that royalty burden until payout. And that is what I had to say for Exhibit A3. I'll request that to be admitted to the record.
Any objection?
I think it lacks foundation, but, I mean, I don't have any certainty as to whether or not these numbers are accurate or correct. I don't have anything supporting that, so I'd object on that basis.
And Mr. Hagan, any response?
I will say that I will certify that the green numbers in the green cells that Whiting provided to me are the exact numbers that they provided to me, and that I can prove that if anybody wants to, and the panel wants to dig through my revenue statements, I can prove that my yellow numbers are correct as well.
I think there's at least enough foundation there for the commission to give it its due weight, so I'm going to allow the exhibit is going to be admitted over the objection.
Excuse me just a moment, I need to. Exhibit A4, this is the second half of that same spreadsheet that I just showed you. It's too big to get it all on one page, and I tried to print these exhibits so that they were, the fonts were big and then they're uncluttered, because I've listened to other NDIC hearings before, and the examiners are always saying, I can't read this exhibit. It's too small, it's illegible, and so forth. So I made an effort to make this more readable for you. This is the expense and risk penalty side of that same spreadsheet. And again, it's color coded in green for Whiting and yellow for my calculations from my revenue statements. And it has the horizontal line for July 2018 initial production. All of those just continue from the first spreadsheet over. And and there's another column I'd like to introduce you to here on well, let me go over the expenses first real quick before I get there. So you take all the expenses, you come up with a total expense amount that's subject to the risk penalty. Calculate all that up, you get a total expense column, then you apply the penalty, and that tells you how much is applicable toward payout on the well. So in column AN on the far right, that's Whiting's original calculation about what the payouts were. Column AO in yellow is my calculations of what it should have been according to my revenue statements. And I'll point out again, the difference in payout date between those two numbers is May 2019. And that is dependent on whether the risk burden, whether the royalty burden is being calculated correctly, whether everything's being reported correctly. And there's another two columns in red here that are a big deal that we're going to get to next. And this is an error that Whiting made on the lease operating expenses. You can see that in December 2018, the lease operating expenses were $31,936 for the well. And then the next month they jump clear up to $495,319 dollars. And that turned out to be an error. That was, I don't know when Whiting first knew about this error, but it was reported to me by one of their payout people that we'll be talking to on expert witnesses today. Was disclosed to me after I applied for the NDIC hearing in March. This error was disclosed to me. And they sent me a modified payout spreadsheet that included what the differences would be in the payout schedule after this error, after fixing this error would be taken into account. And that error alone, notwithstanding the royalty burden and all these other issues that I have, is enough to move the payout on this well up by 1 month. And as I'll prove in my subsequent exhibits, the same error happened to all of the wells, it appears. And Whiting, I believe, said that originally, but they've been kind of walking it back and not wanting to talk about it since then. In discovery, I made a request for production of documents for Whiting to produce updated payout schedules that took this error into account. So I would be able to know when I came to the hearing what to say about how much earlier these wells should be paying out, and they did not produce those documents for me. They gave me old-style updated documents that did not take the error adjustment or the KLJ adjustments into account. And I sent Mr. Mann an email and said, look, this isn't what I asked for. Here's the proof that it's not what I asked for, and I received no response for that. That was September 15th that I sent that request, and I still have not received. They kept telling me, oh, we're going to get that to you. We're going to get that to you, and they never did. So one of the asks I'll be making at the end of the hearing today is that I want those updated documents. And I think that NDIC has the authority to make them turn those documents over. And that, so I wanted to be able to show you these other wells, some like the Wold 5X and the Wold 6X should have paid out earlier too, but since I don't have those, they wouldn't give me the payout documents on that. I can't prove that. I can't show that to you. I can show you lots of other evidence that it happened, but they don't actually have that information available, at least not that they would give to me. So yeah, that's the end of Exhibit A4. I'll submit this for evidence into the record.
Any objections? to that?
Same, it's essentially an extension of the previous exhibit, so I have the same objection.
The objection is noted and overruled. The exhibit is admitted.
Moving on to Exhibit A5. This one is this is the updated payout statement that Whiting sent to me on April 7th, 2022 that takes that lease operating expense error into account. And this is in two halves again, just like the other one. So this first half is the revenue all the revenue. And for the first time on this statement, they showed me they showed me that there where the fees were, for gas and NGLs. So the numbers start making more sense when you can see what the deductions are. But I still do not know what exactly is in these fees. You know, they just take them out, and it just sort of disappears off the sheet. I don't. When they deduct these fees from the revenues, it doesn't count toward my payout, and they pay, as far as I know, they pay no taxes to the state on those fees. They just kind of disappear off the payout sheet, and they don't come into play. So So anyway, that's all there is for this sheet. I just want, this actually came from Whiting. They produced this and sent it to me. And on the next sheet, you'll be able to see the difference in the error. So I'll submit Exhibit A5 to be accepted into the record.
Any objection?
No objection.
The exhibit is admitted.
And so this is the second half of that sheet, which shows the expenses and a 1 month earlier payout on the far right column, column W. It's on line 42, which is would be August 2019. You can see that the balance toward payout has turned to over $16,650, and that means that I'm now paid out. I paid off my burden, my share of the carried interest that Whiting was carrying is now gone, and this is only as a result of that of reclassifying that lease operating expense error. This does not take into account any of the other accounting issues I have with them. It's interesting to note, I'd like to just put this into the record so that any future mineral owners that might listen to this hearing audio will know what happens with when a well pays out is it doesn't happen on a certain day of the month. It's calculated at the end of the month. So this balance that's left to pay out here is pretty low, really, in terms of how much my share of that well cost. This is the total for the well. This is not my share of the well that we're talking about. And I'll be showing you another exhibit that explains this more clearly. But even if the well pays out on the first or second day of the month, the oil company gets to keep all of the revenues and for the entire month, and then they calculate the payout date as of the last day of that month. And they get to charge you the risk penalty on everything too. And we'll talk about that more coming up. But so that's what I wanted to show with Exhibit A6, and I'll submit that to be admitted to the record.
Was that not A6 is the exhibit that one?
I'm sorry, I couldn't hear you.
You offered A6?
Offered A6 to be admitted to the record.
No objection.
The exhibit is admitted.
Okay, Exhibit 7 is another spreadsheet that I made that shows the effect of this lease operating expense error. And they call this, I'll refer to this, they refer to this as the reclass adjustment error. So if I call it the reclass error, that's what that means. And again, it's color keyed, green for Whiting, yellow for my calculations, and the same range of dates from July 2018 to payout in August 2019. And I wanted to show you here where this error happens. You can the vertical lines that are highlighted in coral there. In column AI, you're looking at the original lease operating expenses that Whiting reported for this well payout schedule. Right next to it, I made that column is what the lease operating expense is after payout. And again, these are Whiting's numbers that they sent to me. And you can look at what a huge difference it is starting in January 2019 on line 8, on row 18 of the spreadsheet. Originally, they reported that the lease operating expense went up from $31,936 to $495,319. Then after they fixed this error, you can see that it only goes up from $31,936 to $81,694. And it takes, it never would have reached, toward payout, it never would have reached that original number of $495,000 that they reported. So, and this is a big deal. It happened with all of the other wells too, as I'll be showing you, except one. I don't think it happened to one of the wells, but for most of them it did. And again, in the far right column, I've highlighted the number from the sheet that they gave me, showing that the well paid out 1 month earlier in August 2019, August 2019. So this error happened coming up on 4 years ago, and it's never been rectified. They never caught it in an audit, and I did not know about it until just a few months ago, this year, after I applied for the NDIC hearing. And if you, going into my revenue statement, this is several $100s in revenues that I should have been paid, because the well was already paid out. I should have received the revenue for that month, and I didn't. And not only that, I should not have had to pay the burden. I should not have had to pay the risk penalty either. That's all I wanted to say about Exhibit A7. I'll submit that to be admitted to the record.
Any objection?
No objection.
Exhibit is admitted.
This Exhibit A8 is the World Federal 4474XH payout spreadsheet. All I did on this sheet, I took the exact same spreadsheet that Whiting sent to me in April 2022 that fixed that lease operating expense. You can see the numbers in the lease operating expense column have been changed, have been modified to fix that error. And so all I did with this sheet was to change that royalty burden from 16% of the drilling unit to my decimal interest of 0.0717420. And that changes the payout date. That moves the payout date up to May 2019. So my allegation is that that this, if that burden is, and I'm going to be asking the NDIC to make a determination of whether that burden is correct or not. If my CPA says that it should be based on my decimal interest and that that's what the COPUS accounting standard describes as the proper protocol, the proper accounting method for determining that. If you take that into account, then it changes the payout date to May 2019. Otherwise, there are no differences in the spreadsheet between this one and the original. And just to note that the decimal interest, the percentage of 0.0717420 matches the decimal interest that I receive for my statutory royalty. And I'll submit Exhibit A8 to be admitted to the record.
Any objection?
No objection.
The exhibit is admitted.
Exhibit A9. This is a copy of the COPUS is the accounting society that sets the standards for how oil companies do their accounting. And when I hired an expert an expert CPA and forensic analyst to go over my revenue statements and the payout statements. And the first thing that jumped out at her when she looked at this stuff was that the royalty burden was not correct, for one thing, and also that they were calculating the payout according to gross and not net. And so this table comes from the COPUS AG 13 accounting manual, which describes how to calculate the carried costs on an oil well. And I'll direct your attention to the area outlined in red at the bottom of the page, where it says it is important to understand why farm outs, the farm outs are in the same manual, are structured so that payout is normally calculated only on the interest assigned rather than for the entire well. And they do the comparison of the two columns there. So at the bottom you can see how much difference it makes to payout, whether you're calculating it at gross for the whole unit or taking the decimal interest of the owners into account. And the bottom line is when you calculate it gross, it takes longer for the well to pay out. And I think that's why they do it. That's why Whiting does it that way. It's beneficial to them. They get more revenue from it. And by the way, this is side by side in a column like this, calculated about every 3 months is the way you're supposed to do it, but that's not the way Whiting does it, at least not that they would ever show to me. So I will submit Exhibit A9 as to be admitted into the record.
I'm going to object, Your Honor. This appears to be an accounting standard based on farm outs. There is no farm out here. This is not helpful. It's totally unrelated. And, I mean, in addition to that, you know, there's no JOA or anything where the parties have agreed to, you know, follow a certain set of standards, COPA standards or whatever standards. So, I mean, on top of that, you know, this is entirely unhelpful. It's not appropriate to introduce something relating to farm outs when you don't have a farm out. So I'll object.
So just a relevance objection? primarily
Yes.
there. Mr. Hagan, any response?
I'll just comment that the use of the word farm out in this paragraph is just an example. The same manual does talk about carried interests right in the same section. They could just have easily have applied this to carried interests.
Mr. Examiner, I mean, it may or may not be correct. I don't see what he's referring to. I mean, so I don't think we can take his word for there's a different section that's similar to this to allow this completely irrelevant exhibit to come in.
Right, well, objection is noted, overruled. I think there's enough relevance and the commission can give its due weight, if any, when it makes its consideration. The exhibit is admitted.
Exhibit A10 is the lease operating expense comparison on the paid out old wells. For this, and just for the sake of being able to get it all on one page here, I'm using all of the Wold wells that are known to be paid out, and the two probables are all on here. But this same concept that I'm going to show you here applies to all of the wells except for maybe the Wold 16-7 TFH, which was the first well drilled in the unit. So I've highlighted in coral. Well, let's start with columns B and C. Again, I put the Wold 4XH lease operating expenses side by side, just as I did in the previous exhibit. Those numbers are exactly the same, just to show that big jump in lease operating expenses that occurs in January 2019. Then the horizontal line in coral, I did the same thing for the rest of the wells. I listed them side by side so that you can see on each well in January 2019, that same big jump in the lease operating expenses happens. And I think that's a strong indicator that that same expensing error happened. And I believe Whiting admitted to, they admitted to that too. But again, they did not give me the payout documents that I requested that would show this like it does for the document that they sent me on the Wold 4XH well. And had I not filed for an NDIC hearing, probably this would not have seen the light of day. And this error, that reduces the operating expense by 83.5% after they fix that error on the Wold 4XH well. That's a lot of money that could have been going toward payout, and it didn't. And it probably affects the risk penalty as well. So I went into using these numbers. I went in and checked my September 20. Whiting did supply me updated statements in September 2022, but they're the old without the reclass error being fixed in them. So I went in and looked in those payout statements for the wells I'm listing on this document. And all of them are easily 1 month earlier in payout if you take this into the dollar amounts caused by this error into account. And the Wold 5XH is probably 2 months earlier. The Wold 8H, I'm pretty sure, has paid out within the last 4 months, and the 3H is also a probable. But I haven't, Whiting has not given me any indication on that. They did say that they had a couple of more payout statements for me about a week or so ago, but they never sent that either, so. So, and again, one of the action requests I'll be making of the NDIC at the end of the hearing is that I want to get this error fixed and make them update these payout statements and get it done while Whiting still exists as a company. So I will request Exhibit A10 to be admitted to the record.
I guess I'll make the foundation objection again, and I mean, to the extent that there's speculation that there's some sort of reclass error that hasn't been corrected, I'll object to that as well.
And I guess for the speculation error, I guess, yeah.
No, it's not speculation. Whiting has admitted to this. Their own people admitted, even during discovery, they admitted that this error happened. They sent me the spreadsheet.
I said that has not been corrected.
They sent me the spreadsheet, excuse me, I'm talking. They sent me the spreadsheet with the corrected amounts on it. How is that speculation? How can you call that speculation? They sent it to me. They admitted it in a conference call. It exists, and now they're trying to walk it back and pretend like, this didn't happen.
Objection,
If
Mr.
we can,
Examiner.
if we can
This is
stonewall
argument.
this,
It's argumentative, and I'll grant that one. As far as the speculation, it was to the fact that it hadn't been corrected yet. Is that correct, as far as the
Correct.
speculation?
no,
The objection is overruled. The exhibit is going to be admitted with the same. The commission will give it its due weight when it makes its consideration.
okay, Exhibit A11. This is for the Wold Federal 44-7 5XH well. In this case, Whiting originally calculated that the well paid out in January 2021, and we didn't receive the revenues, the working interest revenues for that one until about November of 2021. What I'm showing here is what the revenues were in January 2021 for gas, plant condensate, plant products or NGLs, and a total of what the property net was. So you take this error into account. There was net revenue of $142.17 for that well in January. And so you multiply that net times 5.25 to get the amount that was applicable. That's a pretty good figure of what was applicable toward pay down that month. And this does not even take the risk penalty. I wouldn't have had to pay the risk penalty either. So this well, when you do the math, it shows in January, and again, this is in January 2021, the net amount left to pay down, if you take the 150% payout dollar amount and multiply it by my decimal interest, there was a net amount to pay down of $59.72. That's how much of my share was left to pay on that well. So if you allow that when this revenue error, not revenue error, but the lease operating expense error is fixed, I would have got that much in revenues. That's enough to jump 2 months, easily jump the payout for January 2021 and December 2020 and bump that up 2 months. There's plenty there to cover my share of the well costs for both of those months. And that's not even taken the risk penalty and the burden into account that I would not have had to pay in January 2021. Well, I won't walk through the math on this one, but I have it here if you want to see it. But again, it's, you know, it comes out to over $1,000. And then when you multiply these numbers, we're only talking, on these exhibits I'm showing you, we're only talking about my interest in one well. There are 15 wells in this drilling unit, so if they made a $1,000 error in their lease operating expenses, that means that, and there were 15 more wells that this could have happened on, that's $15,000, and there's 7 equal shares in my family mineral rights. You're talking about over $100,000 already there, just for this error, just for this lease operating expense error. And we're not even talking about the royalty burdens and the post-production costs and all that yet. And since we're on the subject of the Wold 5XH, I'll just say that, you know, there's another issue of, oh, wait a minute, maybe I don't want to say that yet. Give me just a moment here to look at my notes. Yeah, I can say this now. So, one of the things that I'm saying at the hearing here is that there's one of these wells, the Wold Federal 7H, 44-7-7H, was computed by Whiting to have paid out last year, and we have still never received any of the working interest royalties for that well. And we're coming up on, by their, you know, it's coming up on a year by their calculations, that well paid out, and we've still never seen a dime of it. So I contacted all my family members a couple of weeks ago, and I said, look, I'm going to say this at the hearing. I have to be sure that I'm telling the truth. So I want you to go check your revenue statements and make sure there's no UWI category, which means unleased working interest. That's our working interest portion of the revenues from these wells. Make sure there's nothing there so that they can't try to trip me up on this. And while you're at it, look at your other wells too, and see, make sure that you're getting the revenues appropriately on that. And I found out that my brother said, well, wait a minute, this doesn't match up. He hasn't been getting paid for the Wold 5XH for almost 2 years. That well paid out, according to Whiting, in January 2021, and he's never been paid his revenues for it.
Your Honor, I'm going
So,
to hearsay on that. I mean, he can't testify to what his brother may or may not have been paid. I haven't seen any statements from somebody else's interest, so that's hearsay.
And
I have those statements I can show you. I can prove it, just like everything else here.
as to the statements you can, but as to testifying as to what your brother said, that would be a hearsay type statement that wouldn't be admissible.
I see what you're saying. But the fact exists that Whiting has not paid those royalties. And when were they going to? If I
Mr.
hadn't
Examiner,
called
his
him out on
brother's
this.
not here. He's not appearing, he can't appear on behalf of his brother.
you-
He's not his brother's attorney. His brother hasn't filed an application.
Yeah, you won't be able to testify on behalf of your brother's statements.
If, can he file an affidavit that I'm speaking for him?
Or we could have a supplement after the,
Can we make a supplemental affidavit for that?
well,
I'm
Mr.
going to
Mann.
object to that. I mean, it's not timely. If he wanted his brother to appear and talk about what his brother has been paid, he could have done that. I mean, that ship sailed. I mean, it's not appropriate to, after the fact, try to bring in a complaint that his brother might have.
Well, Mr. Hagan, I will allow you to testify to what is within your knowledge, but not as to what your brother has been telling you, if that makes sense.
That makes sense.
Then please continue.
Okay. I'll submit, excuse me, Exhibit A11 to be submitted to the record.
Any objection, Mr. Mann?
Yeah, object to, like, I guess, the commentary on there. The rest of the exhibit is fine.
To the commentary as the red lettering there? Or-
Yes.
In response, Mr. Hagan?
I'm sorry, I didn't hear what his objection was. The commentary on what?
I think it's the red commentary on the side here.
I guess, Mr. Examiner,
No, I think that's
the
true.
data
I'll
speaks
stand
for
by
itself. I mean, to the extent that there's numbers and data there's foundation for, I have no objection to that. I mean, the numbers are what they are, they speak for themselves, so that part I don't have the objection with.
Sure. Well, objection, I'll overrule the objection. I think we'll allow it and let the commission give it its due weight. So the exhibit is admitted, as is. Mr. Hagan, if you want to continue.
I'll continue then with, excuse me, Exhibit A12. This is a copy of the official state payout statement that you get as a working interest partner with Whiting. This is what they normally produce in the way of a payout statement. So please take a moment to look at it. It's just a one-page item that doesn't give. This is my personal payout statement, by the way. I redacted my owner number and things like that to prevent scammers from getting a hold of it. But this is my personal payout statement. And this is the one from the Wold 5XH well that was printed off in December 2020. So this is the payout statement for that well about a month before Whiting officially declared it to be paid out. And I just want to point out that from reading a statement like this, how would you ever know that lease operating expense error occurred? How could you ever figure that out? And if you look at the, I highlighted in red, it came out kind of faint on the printer, but you look at the gross revenue columns for gas and NGL, how would you ever know that those are really netted numbers and they're not really gross on there because of the post-production costs? And most importantly, on a payout statement like this, the working interest partner, you do not get to see what those costs were that are being deducted from your gross revenues. They're just gone. And you don't really, if you just accept this as gospel truth, you're not going to know that happened. So what all does that cover exactly? We'll be talking about that shortly. So there are revenues that disappear there. And I think the state knows about that too. So the Newfield case is the same thing, where they're taking they're deducting these costs from the State Department of Trust Lands properties. It's the same concept here. They're doing the exact same thing. Only I think they probably take more from me than they do from the state. But anyway, I just wanted to show what a normal Whiting payout statement looks like. So I will submit this for be admitted to the record.
Any objection?
No objection.
The exhibit is admitted.
Okay, moving on to the B exhibits on the yellow tabs in your folders. Exhibit B1, this is the first working interest revenues for the Wold 4XH well. This is from my revenue statement. When I first received the revenues for the working interest royalties on the Wold 4XH well in February 2021 for the well that paid out in September 2019, according to Whiting. And what you're looking at here in the, it begins in October 2019. The well paid out, according to them, in September 2019. So the following month is when I first begin to receive all of the working interest revenues on that well. And I highlighted it in a little red box again there, so you can see that it's an unleased working interest. It lists the taxes and the processing fees that they're taking out. And and I'll point out here that look at those fees. There was $100.04 in unleased working interest revenues on these wells, and they took out $91.43 in these fees, these processing fees. That's 91.5% of all the revenue was taken for post-production costs. in that month. And by the time you get down to the bottom, you know, you're looking at June and July of 2020. By the time you get down there, they're taking more than 100% of the fees. Look at June 2020. $36.03, and they took out $42.66 in fees on that. So when that happens, they not only take all of your gas and NGL revenue, then they dip into your oil royalties too after that to pay that off, and they call it their marketing costs. And we will talk more about that in the subsequent exhibits. But the other thing I wanted you to notice is that you can't see it very well, I apologize for that, but at the bottom, at the very top paragraph there's another little red box that tells you when the statement was generated. It was generated on Monday, February 1st, 2021. So what Whiting typically does is that their close of business each month is around the 28th. So they close their books, they calculate what they're going to pay, but they don't really generate the statement until the first business day of the following month. And that's pretty typical. That's why it says generated on February 1st rather than the check date of January 28th is the reason why that happens. Oh, and the processing fees on the last month down here, at the very bottom of the page, July 2020, that's 118% of the sales is what was charged to me as fees and then taken out of my revenues. And they do the same thing on my cost-free royalty. It's the royalty that is supposed to be cost-free by statute. They take out these fees on that too, and it's the same percentages. So I asked them on a conference call last April. I asked how can they do that, you know, and their answer was, well, it hasn't been litigated in North Dakota yet, so we just go by what other states are doing. But not all states do this. It's illegal in some states. Oklahoma, West Virginia, Arkansas, Kansas, other states, this is illegal to do this. And we'll talk about that more. And I believe the North Dakota Supreme Court has also ruled that you cannot take out these post-processing costs, and that's still in litigation too. We don't have a lease. You know, usually they're talking about leases when they talk about that, but we don't have a lease. We're unleased mineral owners, and we're supposed to be under the protection of North Dakota law on this. I submit Exhibit B1 to be admitted to the record.
No objection.
The exhibit is admitted.
Exhibit B2, this is the first plant product or NGL revenues for the Wold Federal 4XH well. And again, I'd like to show you this first revenue statement, the first working interest royalty revenue statement that I received from Whiting had 14 months of sales on it because they hadn't paid us the revenue until I called them out on it. So this range goes from October 2019 to November 2020. And look at the bottom right-hand corner results for my total plant product sales. This is 14 months of sales, and I lost $52.03. How is that even legal? How's that possible to do that? And they got to use this money as an interest-free loan for 16 months too. So lost my place there. Oh, okay. And so the other thing I wanted to show was Oh, okay, in October 2019, it's close to $100 gross on the unleased working interest. It's $97.61 cents, and a year later, it's about the same amount. So how much money does that come out to that they were taking the whole time? And that was just my little tiny share of the well. They're doing this to everybody, all the unleased owners in the well, and presumably the leased people too are having this taken out of their cost-free royalties. Or excuse me, not the leased people, the unleased people, the other unleased people in the unit are having this taken out. And that's all I will say about Exhibit B2. I'll submit that for the record.
Any objection?
Of the foundation objection, I mean, I don't really have any basis to be able to cross-check the accuracy of sort of the summarized data here.
Objection is, again,
Again, this is my actual data from my revenue statement supplied by Whiting, and I can prove it if you like me to. It's right here on my laptop. I'll print you out a copy.
the objection is noted and overruled. It will be admitted.
I'm sorry, what was it admitted to the record?
It was admitted.
Oh, okay, I didn't catch that. So Exhibit B3, this is the growth of the post-processing costs on the Wold 4XH. Beginning in September 2018, we're in September and October 2018 when they first started booking my revenues toward payout. The costs from my cost-free royalty, they were deducting between 41 to 46% for those months. And it kind of went that same way until April 2019, excuse me. And then after that, these costs that they're deducting jumped up to between 79 and 90%. And then the month after that, 88 to 97%. And the month after that, July 2019, it went 97 to over 100%, 109%. So something happened in April 2019 that caused this huge jump in, they doubled the amount that they were taking on these fees. And I do not know the reason why that happened. I have speculations about what it was. You know, maybe they made built a new plant or something, and they started charging off the expenses to the mineral owners. I don't know. I can't prove it. But something happened, and I want to discover what that was, why that happened, what they were doing or what they were thinking there. So you look at in the lower right-hand corner, my total cost-free royalty came to a penny after they took out all the deductions. And the total for July 2019, I lost money. I lost 96 cents. 1 penny of profit. That's my cost-free royalty you're looking at right there. I'll submit Exhibit B3 for the record.
Any objection?
Just foundation.
The objection is noted and again overruled. Same reasoning. The commission will give it its due weight, so the exhibit is admitted.
Moving on to Exhibit C1. This is a copy of North Dakota Century Code Statute 38-0808, integration of fractional tracts. This is the this is the law, North Dakota law, that was from 2009 legislative session that gives the NDIC the right to force pool my minerals. And it also mandates the cost-free royalty interest of 16%. Now, the legislators who wrote this law were very clear I've highlighted it in red, that an unleased mineral interest has two distinct parts. It has the cost-free royalty interest that the oil company can elect to either pay that or the average of the weighted interests for the drilling unit. And the remainder of the unleased interest, which is treated as a cost-bearing or lessee interest. There are two parts to an unleased mineral interest. It doesn't mean only the cost-free statutory royalty. I think it's very clear in plain and simple language what they meant by that. And you can go, in discovery, I submitted some documents from the 2009 legislative sessions, the House Standing Committee notes, where the legislators are talking about their intent was in passing this law. They were having trouble with non-payment of royalties by the oil companies, and the legislators were hearing enough about it that they decided to do something to make the oil companies comply. That's what this legislation is supposed to do, is make them pay the royalties. And there are supposed to be, there's another statute that talks about the penalty for noncompliance. And the other thing I'll say about this is that when Whiting prints their revenue statements, they don't call the cost-free royalty a royalty. They call that your unleased mineral interest. It's categorized as the letters UMI on a revenue statement. And I will talk, I'll talk more about this in my closing arguments, but I wanted everybody to see this. This is the actual statute in the state of North Dakota. And I'll submit this for evidence, or to be admitted into the record.
Any objection?
I mean, it's not really an exhibit, it's the statute. I mean, to the extent it's accurate, I haven't gone through and looked at it. I mean, I'm fine if you want to admit it.
Sure. The exhibit is admitted and will be evidence due weight.
Exhibit C2 is NDCC statute 47-16-39.1, obligation to pay royalties, breach of contract. Again, I've highlighted in red here. What it says is that if the operator fails to pay oil or gas royalties to an unleased mineral interest owner within 150 days after oil or gas production is marketed from the unleased mineral owner interest owner's mineral interest, the operator thereafter shall pay interest on the unpaid royalties without the requirement that the mineral owner or the mineral owner's assignee request the payment of interest at the rate of 18% per annum until paid. And again, the statute makes it very clear in plain and simple language that the royalties must be paid to an unleased mineral interest owner within 150 days after marketing. And again, when they made this statute, the statute says nothing about restricting the interest payments to only the statutory 16% royalty that is mandated in NDCC 3808-8. That's a made-up interpretation that Whiting chooses to go by. Now, marketing date, and the legislators that wrote this law had arguments about when does this interest begin to accumulate on an unpaid revenues. And they went back and forth. Does it begin at the beginning of the when the oil was sold? Does it start after 150 days? When exactly is it? And what happened?
Mr. Examiner, I guess I'm going to object to this. I mean, the statute says what it says. I mean, we're not looking at what went into the statute. I mean, the law that applies is 47-16-39.1, and what it says now. That's what we look at. That's what we apply. I mean, sort of like the history and the ledge history. I mean, it's not ambiguous. It's clear, so we don't need to look at the ledge history.
I guess, are you arguing there's any ambiguity here in the statute?
No, it's very plain. What my argument is that in order to head off an argument that the law is vague or doesn't apply, and what Whiting said repeatedly in discovery, we affirmatively allege that the NDIC has no authority to do this or that or the other thing. Over and over and over again, they said the NDIC does not have authority to make us comply with anything. And that's why I wanted to print this. The law is clear on this, but they're not obeying the law.
Then, to that end, yeah, we don't probably need to go into the legislative history and everything else. We can probably base it solely
Okay,
on.
that's all I wanted to do was head off the arguments that the intent of the law was not clear.
Sure. And if we need to go down that road later, then we can. But
Okay.
for now, we can.
I'll submit Exhibit C2 to be admitted to the record then.
Any objection?
No objection.
The exhibit is admitted.
Okay, Exhibit D1, that's the last exhibit in the packet there. It has the blue tab on it. Actions requested from the North Dakota Industrial Commitment. And I'm going to read this out right now, and then I'll go to my closing arguments. Applicant Gary Hagan requests that the commission rule in his favor and take action to order the following. One, that the commission require Whiting to immediately correct the lease operating expense reclass error and produce updated payout statements in Excel spreadsheet format for all 15 of the Wold wells in this spacing unit, and to provide copies of the corrected payout statements to the applicant and the Whiting Division Order Department. Applicant further asks the commission to set a reasonable timeline for the completion of the work and penalties for noncompliance. Item 2, that the commission determine the correct royalty burden to apply to the payout schedules and order Whiting to promptly recalculate the payout schedules according to that burden for the 15 wells in this drilling and spacing unit. Number 3, that the commission determine a proper payout schedule for the Wold Federal 4474XH after the burden and reclass error adjustments. And it means after taking those into account. 4, that the commission determine whether Whiting is required to pay the unpaid family revenues for the Wold Federal 447-7H and the Wold Federal 447-5XH, plus January 2022 gas, NGLs, and condensate sales for the Wold Federal 447-6H. Number 5, that all deductions made from the family's statutory cost-free royalties in these wells, except for severance taxes, be immediately discontinued on all future revenue statements for the 15 wells in this spacing unit. Number 6, that all past deductions made from the family's statutory cost-free royalties in these wells, except severance taxes, be reversed and rebooked. Applicant further asks the commission to set a reasonable timeline for completion of the work and penalties for noncompliance. Number 7, that the commission determine whether interest is due and required to be paid at the rate of 18% on all working interest revenues not paid within 150 days from date of sales for the Wold Federal 44-7-4XH, 5XH, 6XH, 7H, and any other wells in the spacing unit that are determined to be paid out at a date that would contain sales that occurred more than 150 days before payment would have been due. Number 8, that the commission require Whiting to provide the applicant with copies of the backup documentation that was used to prepare the payout statements for the Wold Federal 44-7-4XH. Number 9, that the commission order any rulings or orders resulting from this hearing to be made binding on any future oil companies, gas companies, well operators, businesses, or other entities who may succeed Whiting as the well operator and or payer of revenues for the wells in this spacing unit. And number 10, that the commission formally recognize that a dispute exists between the applicant and Whiting so that further actions in this case will not be disqualified due to expiry of a statute of limitations. And I'll submit this exhibit to be admitted to the record.
Any objection, Mr. Mann?
I have no objection.
The exhibit is admitted.
Mr. Examiner, do you want me to go to my closing arguments or do witness?
I would like to give Mr. Mann a chance for a cross-examination first, and then the commission a chance to ask any questions based off your testimony.
Okay, and this would be cross-examination of me or my witness?
Of you.
Okay.
Yeah, thank you, Mr. Examiner. I don't have much. Mr. Hagan, I just want to confirm, you own an unleased mineral interest, is that correct?
That is correct.
And you haven't farmed that out or entered into any type of other contract with anybody else with respect to that interest?
No,
Okay,
there's
so
no.
there is no farm out agreement?
There's no farm out, and
Okay.
there's no history of other owners in the wells either, except for, my father was the original land patent owner.
Sure. And you said that you haven't entered into a JOA or anything else like that that would require some sort of specific accounting principles to be applied?
No, there's no signed agreements with Whiting on any account on these wells.
And looking at your Exhibit A1, I'm trying to understand that. So you're saying that you own approximately 11.4028 acres in the 2,546.57 acre spacing unit?
Yes, that's correct.
So that comes out to a .0044.
Correct,
interest
correct.
approximately.
That's my whole mineral interest in the spacing unit. That includes both my statutory royalty interest and my working interest.
So, based on this, Exhibit A1, it appears you're suggesting that you're not obligated to pay .0044% of the expenses, though. You're saying we can't gross that. We can't attribute your full proportion of that 0044 to your expenses. We have to net that down somehow.
I don't follow your question.
Can you take me through exhibit number A1 and explain to me what you're obligated to pay for your share of the expenses? I struggled to kind of
Oh,
follow
okay.
what you had on that.
Okay, I think I get what you mean. So, let me get, Exhibit A2 shows it better. Let me get that one out too. Excuse me, not A2,
But,
A3.
I was just
A3 is the one that,
curious, let's stay with number A1. I'm
Okay.
just trying to understand.
okay, I'll try to walk you through it here. So, I own a total of 11.4028 acres in this drilling unit. When I was force pooled, Whiting splits this interest into two pieces. They're required by state law to pay me the statutory royalty interest of 16%. So that amount is paid to me each month from the get-go. Well, they didn't start till about 5 months after, but because of the 150-day thing. But they pay that to me each month. Then the other 84% of my interest in that drilling unit it is the remainder of the unleased mineral interest, and that's the part where Whiting takes out the amount of money from production each month to apply toward my share of the costs. So what they do is they take all of the gross revenues for that 84% share. They add up the gross revenues for oil, gas, NDLs, condensate, and everything. They take out the post-production costs. They take out the severance taxes. They multiply that times 16% against the net revenue that's left, and then that is the amount that is left over of my production that they apply to the well payout, to paying down my share of the well costs plus the risk penalty.
So you're not saying that you aren't obligated to pay 16% of your share of the costs, are you? So let's make it simple. Let's pretend a hypothetical that the spacing unit was 2,560 acres and you owned 256 acres. So you own 10% of the interest in that spacing unit as an unleased mineral owner. Follow?
Keep going.
Okay. And then say there were costs to drill and complete the well of, let's just say, $100,000. So with you owning 10%, would you agree that you'd be obligated to pay $10,000, your share of that?
No, you lost me there. What, no, I'm not saying that I'm not obligated to pay at all. I'm saying that all of my obligation to pay, to make payments on this well comes out of this 84% unleased working interest. I do not pay the 16% statutory royalty interest, the cost-free royalty. That does not come into play for the pay down amount. That's just a royalty they pay to me. All of the money, all of the revenues from my share of the well that go toward pay down come out of this 84% that's left over. That's my working interest that Whiting is carrying. And as I just described, they take all the revenues,
Sure. I think I follow the
deductions, and then that is the part I'm obliged to pay toward the pay down on the well.
Sure.
That plus that amount includes the risk penalty, and they just do that every month. They keep paying it down until it's paid off.
One moment. That's all the questions I have.
Are there any questions from commission staff? Seeing none?
I've got it.
Sorry.
Gary, first of all, can you tell us where your 80 acres for your family is located? Can you describe it?
Yes, do you mean like the legal description?
Yes.
It's in Township 153 North, Range 98 West, Section 1, South Half, Southwest Quarter, Banksfield, McKenzie County, North Dakota.
When you talked about the 44-7 4XH, you said that was the first well completed in the spacing unit in 2016. Our records show that well was actually July of 2018.
No, sir. The first well that was drilled was the Wold 16-7 TFH. The Wold 4XH is the first one that paid out.
Okay. You talked about the Copus. Is this, the Copus itself can be revised numerous times through history. Did you use the latest revised Copus?
Yes, I believe so.
Do you know what date that was?
I don't know off the top of my head.
And is this something that you have obtained yourself, or did your witness obtain that?
Both. I originally saw it from my witness, but I also own my own copy.
You talked about 471639.1, and of course even gave us a copy of it. And one thing that you failed to do is you didn't mention on Exhibit C2 that in the last paragraph in black there, right in the middle, it says, "The district court for the county in which the oil and gas well is located has jurisdiction over all proceedings brought pursuant to this section." So evidently you're aware of that, correct?
Yes, I am aware of
So
that.
why
That's what the
are you
statute says.
bringing that in front of us?
Because I want to, in the event that these matters go on to a district court, I wanted to be able to prove that I have exhausted all of the remedies by bringing that up before the NDIC. I'm aware that the statute says that in the matter of the applicability of the being able to make Whiting pay the interest, that is probably out of the jurisdiction of the NDIC, but I still wanted to bring it up as far as, because Whiting's going to argue, in fact, they have argued in discovery already, that the NDIC doesn't have the authority to make them pay the interest. And, but that's small potatoes compared to the rest of the issues on here, but I still wanted to bring it up so that nobody could say I didn't exhaust all the administrative remedies by not presenting it to the NDIC.
And you're indicating that that applies also to the unleased mineral interest that has been carved out for working interest. I shouldn't say the unleased mineral interest, but it's the unleased portion of that. You have a working interest and a mineral interest that is granted, right?
Yes, that's correct.
And under this statute, it clearly says, and you've even got it underlined here in red, from the unleased mineral interest owner's mineral interest. Why would the statute have just mineral interest in there if it also wanted to apply it to the working interest?
I do not know the answer to that.
Okay, I think that's all I had. Thank you.
Gary, I just had one question, and I just want to affirm, when I'm looking at these spreadsheets that you presented, A3, A4, et cetera, the values that I'm looking at there are cumulative, month to month? Or are they a
Yes,
monthly value?
No, they're cumulative. What I did, you can see on a couple of the spreadsheets, there's little pound signs in there. I did add, when I added this up from my revenue statements, I did do month to month, the numbers for each month, and then I added them to make a cumulative running total that would match what Whiting was coming up with.
Okay, thanks for answering my second question is, what are the little pound signs in the columns
Yeah,
that
no,
I'm
I
not
shrunk the
seeing?
columns there so it would fit on one
Okay.
page.
So those are the month-to-month numbers, and then the numbers we're seeing are the cumulative, that's a summation of those monthly figures.
Correct, yeah, Whiting didn't break it down month by month. They just do the cumulative rolling total. But when I did it, I had to be able to add it up and figure it all out and see if it matched up or not. So that's why those little things are in the spreadsheet. It
thank-
was just to make it fit.
Yep. Thank you.
Any further questions from staff? Mr. Hagan, anything further?
Well, I'm unsure of whether, do I continue on with my closing arguments then, or,
Well, I guess if we were going to do a closing, we'd have the other side go first, and then you both do closings at the same time.
okay, I understood that it was me closing, them arguing, me doing a rebuttal. Is that not correct?
Yes. And are you calling another witness, or, I guess,
Yes, I would like to call my witness. Or do you want to take a break first, or what?
well, let's see what kind of, yeah, let's take a short break here. Back
Okay.
here, and,
And then we'll continue with my witness after that?
yeah.
Okay. Let's see, I need that.
And we are back on the record in case number 29290. Over the break, I had a discussion with commission staff,
Missing something in
and it appears that Mr. Hagan, for your expert witness, the written request was only received one day, business day before the hearing date, and under Administrative NDAC 43020388.2, the commission does require that the written request is made at least 2 business days prior to the hearing date. So I guess, Mr. Mann, I would turn that over to you. Do you have any objection to allowing this witness to testify here today?
I mean, I guess I would object that it's not, that there hasn't been timely compliance with the NDIC rules and regs. So for that, for that reason, I would object and on that basis.
I don't understand about the written thing within a day.
So yeah, so under the commission, so it's NDAC 43020388.2. The commission may, at its option, allow telephonic communication of witnesses and interested parties, but the procedure shall be as follows. And under sub 1 there, telephonic communication of an applicant's witness will only be considered if a written request is made at least 2 business days prior to the hearing date.
I was unaware of that rule.
And my understanding is that that request was only made yesterday.
I'm not sure about that. I've called the NDIC several times to ask about procedural questions, and they always just say, we can't give legal advice. But yes, I was unaware of having to make a specific request to do that, so I don't know what to say about that.
And Gary, we would stress that this is a written request.
Are there any alternative methods of doing that? I mean, I've listened to other hearings where, somebody like an engineer, a petroleum engineer, or somebody's going to testify and they just swear them in over the phone and run with it. Does that, have they submitted written requests for all of those?
Yes, that would
All
be
the
the
time.
rule, is if there's going to be telephonic communication, there would be a written request.
Okay, well,
Business days ahead of time.
I guess there's nothing I can do about that then.
So I guess
If they don't want to allow testimony, then I'll just go ahead with what, I'll just point out that everything that I've said here today and all these numbers and facts that I've been presenting have been reviewed by my expert CPA. She has 2 reports, I believe, and her credentials, her expert disclosure forms, and all of that are on file already. And that she has reviewed everything that I'm going to say and would corroborate that in her testimony.
So I guess to that end, we cannot allow the telephonic witness to testify here today, but as you said, whatever's in the record is already in there.
One question, will I have the opportunity to cross-examine their expert witnesses then?
Yes, you will be given that opportunity. So is there anything further, Mr. Hagan, before we go into Mr. Mann's argument?
Yes, I have another question. So at what point, what's the procedure from here forward? Do I get the opportunity to speak again after he argues, or do I have to do my closing arguments now, or?
So I guess if we do closing arguments, which I suppose we will, I will allow Mr. Mann to do his case, and then we'll allow closings at the same time, if that makes sense. So you complete your case here, and whatever argument you're going to have, then I'll turn it over to Mr. Mann for his argument, and then you'll have cross-examination opportunity. The commission will question his witnesses, and then both parties will be given an opportunity for a closing statement.
Okay, thank you for clarifying that. I think what I'd like to do is a little recap of the kinds of issues that my accountant found when she started reviewing my revenue statements and these payout statements that Whiting sends. I think as I mentioned before, the first thing that jumped out at her was that the royalty burden is incorrect. And she was very adamant that she would go to the mat with the NDIC on, or anybody on that, that royalty burden should be calculated according to my decimal. It should take my decimal interest into account. And Whiting claims that it does, but I don't see where, so I'll be asking them about that. And the other another question that she had was about how they do their cash, they say they do their accounting on a cash basis, and that partly explains why the revenues didn't match up line for line when I compared them by month, because they don't really book the revenues till payout until they get the money. So for oil, that would be a month after the sales, and for gas, there's a lag of 2 months. So when you stagger that, when you take that into account, you stagger those numbers the way that they claim that they're getting the revenues, then it evens out a little bit. It's not as egregious as it was before. But I have questions about how they do their expenses then, because it looks like they're not booking revenues to pay out until they actually get the money, even though the law says when marketed. And but I've had conflicting stories from them about when the expenses get booked. They told me on, well, here, I can just read it to you. So in a written correspondence on April 7th, 2022, they said, we add in the expenses and revenue in the month that we pay the invoices or receive payment for revenue. But then in discovery, they said, Whiting utilizes a cash basis accounting methodology for the wells at issue. Under that methodology, Whiting adds expenses in the months that it receives invoices concerning the well. And receiving an invoice is not the same thing as paying the bill. And so I wanted, one of the things I wanted my expert witness to talk about was that the fact that the revenues and the expenses have to balance out on this. They can't have their cake and eat it too. They can't book the revenues one way they want and then book the expenses another way. And so we were going to go into a discussion about that. And then there were other issues that she discovered when reviewing my royalty payments, my royalty statements rather, and the payout statements. And then she was going to talk about how COPUS does the royalty burden accounting. But she was very adamant about that the burden was not being charged correctly. And so that, I believe that's one of the things I'm asking for in Exhibit D1 for the commission to determine what that correct royalty burden is to apply to the payout schedules. Another thing I wanted to stress is that this lease operating expense error is an overcharge. It's an incorrectly charged expense, not an incorrectly paid royalty. On the exhibit that I showed you, I can't remember if I showed you that the royalties go down too, as when the lease operating expense is going down. Something happened in there where they were booking oil royalties as lease operating expenses. I'll have to ask their expert witness to try to explain what all that is about, but that was another thing I wanted to talk with about my expert witness. And she is has a long history of experience in these matters. She's won big cases in other states. She's testified in district court in North Dakota, I believe, before. And so Whiting is dodging a pretty good bullet by not being able to have her testify today. But the rules are what they are. So I'll accept that. And I will give, I still want to make a closing argument, but I'll let Mr. Mann
All right.
have his say.
Well, did that raise any questions for you, Mr. Mann, to cross, or any questions?
No, Mr. Examiner, thank you.
All right, then we will move on to your case in chief, Mr. Mann.
Yeah, thank you, Mr. Examiner. I have two people with me at the table, Amanda Stevens and Chance Crueljack. I do intend to call Amanda Stevens to testify with respect to the accounting issues, the payout issues, and sort of the communications that have been had with Mr. Hagan. Mr. Crueljack is a landman. I primarily had him here in the event that something came up land-related that we may need to address, but so far it appears that that's going to be unnecessary, so I likely will not be calling Mr. Crueljack. And Mr. Examiner, this is primarily a legal issue, so I mean, up front, I'll address some of those issues. It really doesn't appear that there are really any relevant factual issues in dispute with respect to, the numbers. I think sort of the disagreement and, kind of why we're here relates to sort of different interpretations on North Dakota law. Mr. Hagan, his application, it didn't challenge, whether certain costs are reasonable or actual costs. That's not what it's about. He's disputing, what costs can or can't be deducted from the statutory royalty, and whether or not I think 1639.1 applies. So, I mean, if you look at his application, a lot of what he's asking for are things, as Mr. Hicks kind of pointed out too, that maybe beyond the scope of what the NDIC has jurisdiction to do or to address. So, for example, in his applications, his sort of prayer for relief in paragraph 8, the first paragraph on the last page, he's asked that interest be paid as required by law at the rate of 18% on all working interest royalties not paid. Well, as Mr. Hicks indicated, there's a couple issues with that. One, that's a district court issue. NDIC does not, enter orders or judgments for, certain amounts of money. And the other problem with that is that that statute, 47-1639.1, it doesn't apply to allegedly late payments of working interest. It applies to late payments of royalty. And Whiting's witness will testify that Mr. Hagan has always been paid his statutory royalty, to the extent that there have been instances where the working interest portion, may have been paid beyond a certain date. That's not subject to the 18% interest. I mean, Mr. Hagan pulled the statute and has it, I believe, as Exhibit C2. And if you read that, the operative language there, if the operator fails to pay oil or gas royalties, keyword there, royalties, to an unleased mineral interest owner within 150 days after oil or gas production is marketed from the unleased mineral interest owner's mineral interest, the operator thereafter shall pay interest on the unpaid royalties. So to the extent that there's an instance where the 16% was not paid timely, that's where 18% interest comes into play. It does not come into play on the working interest portion, and that's what we're looking at here. In his application, I'm not sure if it's just a misinterpretation of the statute or an attempted workaround, but he's got, in the application, he wants 18% interest on all what he terms working interest royalties not paid. There's no such thing as a working interest royalty. It's either you've got the royalty and you've got the working interest portion. They're two separate things. So that section, it really doesn't apply. Then if you go on in his application, sort of the next sort of point of contention in his next request, he's asking that all deductions made from the statutory cost-free royalty, except severance taxes, be reversed, rebooked, and promptly paid and discontinued. So the issue there, again, this is a legal issue. It's how you interpret 380808. Mr. Hagan takes the language in 380808 for the statutory 16%, the cost-free royalty. He interprets that in a manner that Whiting would not be allowed to pass through the post-production cost deductions that are taken by Whiting's midstream gatherer that then get passed along. So basically, he's saying that you can't, that post-production costs can never be deducted from the statutory royalty. That's not correct. North Dakota's an at-the-well state. If you look at the Supreme Court's Bice versus Petrohan, Blasey v. Bruin, cost-free royalty does not mean that post-production costs cannot be passed on prior to calculating the royalty. It's the opposite of that. Because it's an at-the-well, that interpretation means that you can deduct the post-production costs from a, so cost-free or free of cost, that's been looked at by the court, that's been interpreted, and those costs can be deducted prior to calculating the statutory royalty. So, so you take away those issues, and I mean, those both being legal issues, there's really not much left to address or dispute. I am going to have Ms. Stevens kind of walk through the communications that have been had with Mr. Hagan and his consultant over the last year, the efforts that have been made to work with him and get him the information he needs and to kind of help him understand what Whiting has done with these interests. And then I think I'll have her walk through the payout statements and sort of explain how Whiting does calculate their payout. And then there's also sort of what he refers to as the correct royalty burden to apply. Ms. Stevens can also address, that royalty burden and how that's determined. So with that, I'll call Ms. Stevens at this point.
All right, Ms. Stevens, please raise your right hand. Do you solemnly swear or affirm under the penalty of perjury that the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
I do.
Amanda, can you give us your name and your business address?
Amanda Stevens, 1700 Lincoln Street, Suite 4700, Denver 80203.
And who do you work for, Amanda?
I work for Cord Energy and its subsidiaries.
Okay, and one of the subsidiaries is at Whiting?
Yes.
Okay, and what's your position?
I'm the controller over operational accounting.
Okay, and what are some of those primary duties?
I oversee the operational accounting team, whose duties include billing out to our partners, processing revenue, production tax, payout statements, etc.
Okay. And Amanda, are you familiar with Mr. Hagan's claims that he's brought in his application and reference today regarding payout and deductions from his royalty?
Yes, I am.
Okay. And did you look into those complaints after becoming aware of them?
Yes, I did, along with others on the team.
Sure. Can you just describe for us what that entailed?
We took the example that Mr. Hagan and Mary Ellen provided to us where they were in disagreement with our calculations, and we compared that to our statements. And then we responded with explanations for any variance that where they had a difference in numbers, and explained to them why we felt there was a difference in those numbers, and offered to have a call with them to discuss those variances.
Let's maybe elaborate on that a little bit. Have you had communications, I guess written and verbal, with Mr. Hagan and Ms. Denemy regarding the complaints?
Yes, we have. So I do have a list of the different time and connections.
Yeah, I think it would be helpful if you just kind of walked us through.
So that I know that Mr. Hagan had reached out to Bailey Wolf, who's one of my accountants historically, to request payout statements. I have record on November 8th of 2021, Bailey received a letter from Miss Denemy, Mary Ellen Denemy, and Mr. Hagan, describing reasons why she believes the statements were incorrect. I worked with Bailey, the accountant who works for me, and one of our landmen in the office to review all of the variances and concerns. And we responded on November 17th. And Ms. Denemy said she would review our information and get back with us. She responded in a letter on December 29th. I was not aware of that response until closer to March. It was received by Bailey Wolf in our accounting department. And I worked with Bailey again on that one, and Brandy, and I believe my recollection is we sought outside counsel as well. And we responded on April 7th, and this was the response explaining the variances where we had gone through Ms. Denemy's spreadsheet and then offered to, I felt like it would be better to have a conference call to talk through those and explain what the variances were and understand where Ms. Denemy was coming from. And then we had several communications over the next couple weeks to determine a time that would work for all of us. And we responded to other questions in the meantime, and ultimately had a conference call on May 5th. And we described our procedures for calculating payouts. We also discussed the cost-free royalty concerns and the post-production costs. And one of the main areas where we went back and forth was about the royalty burden that was coming out of the payout calculation. So I offered to provide, currently, let me just step back, all of our payout statements are at a gross level. So 100% of the revenues and expenses. And at that point, I offered to do a net payout statement. So I calculated the payout in the same way it would be at gross, but at Mr. Hagan's net working interest. And I provided that to them on May 10th and offered to do a call to walk through that and answer any questions. I had not heard back from them. I followed up on May 11th and 12th, but they were not available to do a call. And then I had gone on vacation. May 23rd, I followed back up, and Mr. Hagan responded that we were at an impasse, and that he plans to move forward with the hearing. After that, we followed up to make sure Mr. Hagan had what he needed, because after reading through the court documents, it sounded like he had not received some payout statements. So we sent payout statements to him on July 12th. July 12th is when I asked him if he needed anything else, and he asked for additional payout statements, and we sent them to him on July 15th. So I think we communicated quite a bit over the past year with them.
Sure. And on the royalty burden aspect, calculating that with gross revenue and expenses, does that just mean that he's obligated to pay his, full proportionate share relating to his interest?
Yes.
He's not covering anybody else's interest by applying gross, is he?
No.
Can I have you look, just briefly, do you have exhibit number 1 and exhibit number 2?
I believe so. Yes.
Let's start with exhibit number 1. And you touched on this in sort of your recitation of kind of your communications. Is exhibit number 1 a letter that you prepared and sent to Mr. Hagan and Ms. Denemy?
Yes. And that one was dated, November. I don't have the exhibit numbers on here. That one was dated, yes, November 15th.
And that addressed certain specific questions that Mr. Hagan had with respect to his payout issues?
Yes.
And then looking at exhibit number 2, do you have that? Can you just describe what that is?
This was the letter where we walked through the various concerns that Ms. Denemy had brought to our attention and explained the variances and our stance on the various topics that she had brought up.
Okay. So you'd responded back in November, addressed questions, then there were additional questions, and you again responded with this letter?
Correct.
I'd offer exhibits 1 and 2.
Any objection, Mr. Hagan?
I don't have a copy of those exhibits.
So 1 and 2 are just like a couple
Or
of words.
these are,
1 and 2 are right here, Mr. Chairman.
yes, those were mine. So which estimated payout statement is this? When was this sent?
Right now, we're just on the letters, Mr. Hagan. I haven't got to that
Oh.
exhibit 3 yet, so it's just the first 2 pages.
Just, yeah,
Oh,
do you-
okay,
any
yes,
objection
this-
to including 1 and 2 in the record?
Okay, this looks like the letter.
There's 2 of them.
Yes. If there
Oh, okay.
isn't any objection, the
No
the
objection.
exhibits will be admitted.
So let's go ahead and move on. Do you have a copy of Exhibit 3, the estimated payout statement for the Wold 4XH well?
Mine says Exhibit 4, but,
Oh, that's for the 5.
oh,
Exhibit
yeah.
number 3.
I thought I had them here, sorry.
That's okay. You can use that one.
Okay.
Can you identify that, just identify that exhibit, what we've got marked as exhibit number 3?
This is a payout statement that we provide. We calculate the payout in Excel using data that pulls directly from our accounting system.
And that is for the Wold 4XH well?
Yes.
Okay. And can you walk us through the payout statement? Take us through the categories and explain, how you calculate payout?
I can. Our payout statements, like I mentioned before, are all calculated at gross. So it's 100% of the revenue and expenses for the well. This particular statement accumulates the numbers as it goes down the various months. Across the top, the first section goes through the revenue, oil revenue, gas revenue, and NGL revenue. Those revenues all include the gross sales in addition to deductions for post-production costs, if there are any. The next column are taxes. Those would be severance taxes or production taxes required by the state or local entities. And then the royalty revenue column is the royalty burden that the well is required to pay. In this particular case, it's 16% burden for the well. And then there's a column for the net revenue of less burdens. And then the next 4 columns are capital costs. There's tangible drilling costs, intangible drilling costs, tangible completion costs, and intangible completion costs. Those columns are all subject to a payout penalty. So when the calculation comes across the spreadsheet, it applies a 50% penalty to those columns. And then there's the next column, WO stands for workover, and then LOE for lease operating expenses. And then surface is the last column, which are surface expenses that would be like building out the central tank battery or anything above the ground. And those all are are deducted at 100% of the cost. There's no penalty applied to those. And then the next column is a total of those columns, total of the expenses, and then the 150% payout has the penalty applied to the capital columns that I mentioned.
And Ms. Stevens, Mr. Higgins raised concerns or made complaints about post-production costs that are passed through from your gather that are deducted from the royalty on 380808. Can you explain what those are and how that gets applied?
Those deductions are all coming from the gas processor. So we use One Oak for these particular wells. And any deductions are directly passed through from what they've deducted on our statements. And that they might include processing fees, marketing fees, et cetera.
And there aren't any other, like, additional whiting charges, are
No,
there?
we don't add anything to that deduction.
What about, there were also, during Mr. Hagan's testimony, there was some testimony relating to, I guess, like a reclass error on some lease operating expenses. Can you explain what that involved? Kind of take us through and what was done, how that was corrected, and if it was corrected?
Yes. There is a financial reclass that's required by our financial reporting team before we report our financials that requires a reclass between oil revenues and lease operating expenses. And that reclass was incorrectly picked up on the payout statement. So it would have inflated the revenue and inflated the LOE, or lease operating expense. So when we corrected that reclass or removed that reclass out of the payout statements, it would have reduced the oil and reduced the lease operating expenses, and that's why it had a minimal impact on the payout date. I also then, to confirm that the numbers match back to Mr. Hagan's revenue statements, went through Ms. Denomy's example, right? Apparently Mr. Hagan had prepared it, and explained the row where all the revenues had tied back to his example that he had sent us in a cumulative total.
Is that, do you have that reflected in Exhibit 5?
I don't believe so.
Let me just move on then. If you can look, do you have Exhibit 5 in front of you?
This is the net. I don't think that we included the, I only have the letter where I explained to him
Okay.
where it had tied out.
Mr. Examiner, can we take just a very brief break?
Sure, we can take a quick 5-minute recess here.
Okay.
Back at 11:35.
Finish that explanation, the LOE reclass was a reclass between oil revenues and the LOE, which was then represented in new statements that were provided to Mr. Hagan.
Then I'd like to move on. Well, exhibit number 4, I don't think we really need to go through that. That's just, it's the estimated payout statement for the 5XH well. There's really nothing, is there anything different, I guess I'll ask you, with respect to how payout is calculated on the 5XH versus the 4XH?
No, there's nothing different.
I'd like to move on then, Amanda, if you can identify exhibit number 5 for us. And particularly, if I can have you turn to the 3rd page. And can you just take us through that and kind of explain what you're showing here?
So this is the example, and it's a little bit small, but this is the example that we prepared for Mr. Hagan to show him that if we netted everything down to his working interest, so we took the gross statement that we had provided to him before, netted everything down using his working interest, which is highlighted up at the top, including the royalty burden being netted down, the payout would come out to be the same. It would pay out on the same date.
Okay. So you're not saying that netting is the appropriate method, the gross is the appropriate method, correct?
Industry standard in the 28 years that I've been in oil and gas, payout statements have been calculated at gross, but
even
the
if-
results are the same either
Okay.
way.
Thank you. And then, Amanda, circling back to Mr. Hagan's complaints that he's entitled to 18% interest. I mean, it's a legal issue. I'm not going to ask you to interpret the statute or anything like that, or give your legal opinion. But I just want to ask, has Mr. Hagan, he's always been paid his 16% statutory royalty? Is that
Yes.
correct?
Yes.
Okay. So there weren't periods where he wasn't paid for many months, the cost-free royalty under the statute?
His royalty payments were paid within 150 days.
Okay. That's all the questions I have for Ms. Stevens. But I guess I think I forgot, Mr. Examiner, to offer exhibits 4 and 5.
I believe 3, 4, and 5. I don't remember if 3.
Oh, 3, 4, and 5? Okay, 3, 4, and 5.
I guess, Mr. Hagan, did you have any objection to admitting that, the exhibits 3, 4, and 5 to the record?
I have, no, I have questions about it, but I have no objections to the exhibits themselves.
Sure. So we will admit exhibits 3, 4, and 5. And I believe, Mr. Mann, you said that was all you had for that witness?
Yes, Mr. Examiner, thank you.
And then we will go ahead and go to your cross, Mr. Hagan.
I have some questions here. May I have just a 2-minute break right before I begin?
I suppose we gave that to the other side, so yeah, we'll give you a quick 2-minute break.
I'll be right back. Okay, I have some questions I'd like to ask first, and then I have additional questions about the exhibits here. So, Ms. Stevens, you've described the reclass here. I think I don't need to have you repeat that again. When did Whiting first become aware of this reclass error?
We became aware when we were tying out the spreadsheet that you had sent to the actual revenue statements.
So that.
So as we were tying out your spreadsheet.
What month? What date?
That would have, I believe, our response to you was in April of 2022.
Okay. So that was the first time that you realized that it had happened. And so I think I saw on the one, I'll get to that eventually. What was the source of this error? Was it code in a computer program, or was it a human error, or how did it happen?
It's really not an error as far as the numbers as they come through our financials. It was a reclass that was getting picked up on the payout statements as part of the way the accounting system pulls in the information. So the reclass should not have gotten picked up.
Is the reclass an automatic computer-driven thing that
It's-
happens?
In the accounting world, we process something called journal entries. So it was a journal entry that was getting picked up.
Okay, and where do the journal entries come from then?
They're produced by our financial reporting team, the team who prepares our external financials.
Okay, so at some point there are people that enter something into a computer and it enters the system that way?
That would be correct.
Oh, okay. So you sent me a statement on the World Forex that was a revised payout statement that showed that when this reclass takes effect, that the payout date on that well moved up by a month. Is that correct?
That's correct.
Okay. And so it's not a matter of argument that this happened and that the payout date changed.
I would agree with that.
Okay. And have you looked at the other Wold wells to determine if that same reclass thing happened with those?
Yeah, I actually personally did not, but I had asked Bailey Wolf, who works for me, to look at those.
And what was the outcome of that? Have they found that?
The reclass happens on every well in this area, or every well.
So every well in this drilling unit, spacing unit, is affected by that error, and so the payout dates may move up on the other ones.
I would agree with that.
Okay. Why have I not been provided with copies of that I requested of?
It was my understanding that Bailey provided those updated copies to you.
But the copies that I received did not have the lease operating expenses did not change. They were still the old statement, and I made Mr. Mann aware of that in the middle of September, but I never received a response as to where those.
I guess I'll object. I don't agree with that statement. But
I would just direct make sure you're directing questions to the witness.
Oh, okay, sorry. Okay, so, so what happened in January 2019? Why does that reclass, why does it happen then? Why does the incorrect lease operating expenses begin in that month?
I don't know for certain. I would need to consult with our financial reporting team.
But have you found that that's consistent though with all the other wells? Is that the same, the source of that adjustment happens at the same time for all of the wells?
I did not go back and look. I just know that we removed that particular entry from the payout statement.
And so what is the progress then of if they've looked at these payout statements and recalculated them, what is the progress currently towards sending that to the division order department in order to correct the revenues that would be payable for those months earlier that the wells are paying out? What's the progress of that? Is that underway or?
I believe Bailey's provided the payout statements to the division order department.
I've not been notified of that either. Uh, Does Whiting have their own auditors or independent auditors that go over this stuff and where it's something that would have turned up under an audit?
We're a public company, so we do have auditors who audit our financials. We also do have partners who are allowed to request joint interest audits. I'm not aware of anyone who's audited the payout statements specifically, but certainly the procedures around processing invoices and passing through expenses to our partners.
Okay, is my risk penalty amount affected by this reclass adjustment?
I'm not sure I understand.
Well, when you take the earlier well payout date, as a result of this reclass error, the payout date of the well moves up, and so there's going to be a risk penalty that I had previously paid that's being left behind now. What happens with that?
So if we recalculate the payout statements like we've done, it recalculates it across the board.
So
So
the
it would
risk penalty,
So it would adjust,
the risk penalty that I paid will be refunded to me then?
it will adjust the payout date, so everything shifts up by the 1 month.
But will I get the royalties or the working interest revenues for that month then? For example, if it paid out in August instead of September, then I am due the working interest portion of the revenues for September, is that correct?
Yes, for that 1 month
Okay.
earlier.
And then, since I was already deducted on the risk penalty, then that goes away too.
I believe so, if I'm understanding what you're saying.
Okay.
It shifts everything up by 1 month. So you would be obligated then to pay the expenses for that additional month as well.
I'm sorry, say that again, please.
If the payout moves up by 1 month, you would receive revenues for that additional month, and you would be required to pay expenses for that month as well.
Oh, correct, yeah. I would be responsible for the JIB on that. Yes, that's correct. But I wanted to make sure about the burden and the risk penalty had already been calculated on that, so. And so it is Whiting's intention to pay us those working interest revenues that result from the reclass adjustment.
Yes.
Okay. I think before I move on, I got just a couple questions about your exhibits here. On the last page of exhibit number 5, page 3 of exhibit number 5, what does the yellow highlight next to the date of August 8th, August 31st, 2020, what does that highlight mean?
I'm sorry, it's a little bit small.
Yeah, the row for
That-
oil revenue is highlighted.
That row actually fed through from the gross payout statement. That was the row that I had highlighted that tied back to the spreadsheet that you'd sent us to show that the revenue is tied to your cumulative revenue in your spreadsheet.
Oh, okay, and it's offset because it's because the oil and gas don't,
Yeah.
they go
Yeah.
in the same month. Okay, thank you. And is this exhibit number 5, is this adjusted for the lease operating? No, it's not. Is this adjusted for the lease operating expense? So it still shows a payout date of September 2019, but it hasn't been adjusted for the reclass. Is that correct?
I don't know for certain. I'd have to tie it out. We took the gross payout that we had initially been working with and then netted it down to your net interest to show you that the net burden nets down to what you believe the royalty burden should be, was the intention of this payout statement. Versus you had disputed the 16%, so we were showing you that if we took the 16% times your working interest, it came down to the net royalty burden that you were expecting.
Okay, thank you on that one. Then on Exhibit 4, page 1, is the Wolf 5XH well. And it looks like the reclass has not been done on this one. So it's still showing a payout date of January 2021. Do you know how far the payout date moved up on that one, on the Bold 5X?
I don't know exactly off the top of my head.
And I would like to request copies of those updated statements, just for the record. Okay, I have some other questions about expense booking and the cash basis accounting methods. I would like to clarify, when exactly do the expenses get booked to payout? Is it when you pay the bill or when you get the invoice?
It is when we get the invoice.
It is when you get the invoice. So it's, and then when would those expenses be paid then? What's the time period that you have to pay the expense?
We pay depending on the vendor terms, so it could be either in between net on receipt up to 30 days.
Up to 30 days. So the expenses would get booked to pay out in the month that you receive the invoice, but the bill hasn't been paid yet, correct?
There is a possibility,
There's a
but we also
possibility of
could
that.
have paid it.
But my revenues are never booked to pay out until you actually receive the payment from whoever bought the oil and gas products, is that correct?
That's correct. We process the revenue and expenses the same as we process revenue that's paid to royalty and working interest owners and the joint interest bills that go out to partners. It's a consistent practice.
So I don't understand it. It seems to me that there's an inconsistency there, that the revenues don't, the revenues, my revenues that should be going toward payout don't get booked until you actually receive the money, but you go ahead and book the expenses as soon as you get the invoice. And so I'm getting, I'm not being credited on the one hand, but I'm being forced to pay on the other. I think cash basis accounting should be the same. It should be, both sides should be treated equally. And I'm sure
I believe we're processing consistent with industry standard.
when does Whiting pay the severance taxes to the state on these sales?
We pay them based on the regulations. I don't know the timeframe specifically.
I mean, yeah, I was referring to, is it the time of marketing, or do they do the same thing as they do with my revenues? Is it offset by a month or two for oil or gas before they pay the state?
There are requirements by the state. I don't have them off the top of my head.
What is the reason why Whiting did not start booking my revenues to pay out until November 2018, when the sales began in July 2018?
I don't have an answer to that, Mr. Hagan, right now without going and looking into
Because the expenses were already rolling, but
sometimes it takes some time for the division order title to come together for us to be able to process. But I don't know, I can't say for certain in this case without looking into it. But it certainly comes to the same result because by the time it pays out, all those revenues have been caught up.
I'd like to ask some questions about the royalty burden, because could you please explain exactly what is the burden and why is it charged?
So each well is obligated to pay royalties, which is what we call the royalty burden. And your working interest portion is burdened by a portion of those royalties before you get paid your revenue, which would be your net revenue interest.
But why do they charge that burden, though?
I don't know, Wade, if you can explain that better than me.
What exactly is it for? I mean,
I think she's answered the question to the best of her ability.
Yes. If she doesn't know, that is her answer.
oh, okay. So I guess my next question was, why is the burden assessed against the entire drilling unit? But that would fall under the same thing, so. Does Whiting know what the actual burden is? I mean, why is it 16%? Why 16% and not 12% or 20%? Or how do they decide on that?
I don't know that that's within my area of expertise either. That would be more of a land question.
Okay, on the post-production costs, let's see, I lost track of my note on that. You were saying that Whiting sells the gas to One Oak. Is that an exclusive contract? Is One Oak the only processor that you sell the gas in jails to?
No, not at Whiting as an entire company. We sell to many purchasers and processors.
Oh, you were talking, oh, here it is. You were talking about, so you, on the post-processing costs, you sell the gas to One Oak, they process it, and then they give you, and then the costs are all costs that come from them, and then they just return you a number?
Yeah, we have a statement and it details out all of
Okay,
the
so the costs all come from One Oak
Correct.
and not Whiting, okay. Is the sale price of the gas discounted from the actual market price at the time that you sent it to One Oak?
No, not that I'm aware of. I'm not in marketing, but I know that we work with multiple processors and we pass on whatever we get paid and whatever's deducted.
Do you have any any knowledge about why the deductions, these post-production costs went up so much all at once in 2019, in spring of 2019?
I don't know specifically, Mr. Hagan. I know that when gas prices drop, there are certain fees that are set fees, so percentage-wise, they appear higher, but I haven't looked at these specifically.
And in Discovery, I asked some questions about what the relationship was between Whiting and Cord. I know they've had this merger, and Oasis and Whiting merged and formed Cord Energy, but those were all denied to be answered. And you said when they swore you in that you work for Cord now. So my questions are, does Cord do their payout accounting the same way that Whiting does? Does the Oasis side?
Mr. Examiner, I'm just going to object on relevance. These are all Whiting. Whiting is the operator of these wells, was during all relevant times, still is. What Cord does going forward is not really relevant to this case.
Mr. Hagan, in response to, I guess, the relevance of this line?
No, I think it's relevant. Whiting has already filed documents with the state of Colorado to finish dissolving the company. They're going to lay off over 100 more people and close their offices in Denver. So I'm
going to object again. It's relevance.
I'm foreseeing at some point Whiting's not going to be the operator of these wells anymore, and I want to establish that. Is that going to happen?
I guess looking at the time frame that we have, I guess that doesn't court doesn't seem to be involved with the timeframe we're looking at. Is that?
So we're only looking at the past time frame up until the present.
That's my understanding of your application, yes. So, yeah, if we can keep the line of, direct questioning to this witness and then try to keep within the scope of the application.
Okay. Well, I'll ask one more question. This may not be within the scope of expertise either, but, so when, I have a question about whether double dipping is occurring on these expenses. So on the one hand, they take out post-production costs from my, when they compute my share of the paydown amount for the wells each month. They're already they're netting out all the post-production costs before they report the gross revenue numbers. But they also take those same fees out of my cost-free royalty. I'm getting charged twice. They're getting me once on the front for the payout, and then again out of my cost-free royalty check. So how do you reconcile that?
So when we calculate the payout at gross, we need to take in consideration the deduction of all the post-production costs for the well in order to determine the payout. I think the example that you had requested where we prepared the net payout statement for you, you could more clearly see that we netted everything down by your working interest and only your working interest share, which should prove that you're only paying those post-production costs on that interest, and then you pay your royalty interest when we deduct it from your check. And I'm happy, I mean, we offered to walk through that net payout statement with you. That offer is still open if you'd like at some point.
Yeah, I would like to do that because I don't understand it. I don't understand how they it appears to be billed twice to me.
We netted the net payout statement down by only your working interest to show you that if you net it all down, it comes to the same. But in order to calculate a well payout, everything has to be at 100%.
I think that's all the examination questions I have.
Are there any questions from commission staff?
Amanda, you were talking on Exhibit 3 about the 50% penalty. And I've got a couple questions just on the columns, starting with TDC. Oh, that's the tangible drilling costs, right?
Mm-hmm.
And then intangible drilling costs is next, is that right?
Yes,
And then, was it tangible completion costs?
correct.
Okay, and then intangible. And the workover column, what does that include?
That would be any work that's done after the well has been completed. And typically it's expense. So it's not adding to, we consider it adding to the reserves of the well. It would be maintenance expense if a pumping unit needs to be replaced because it wore down or something similar to that.
Okay, and you're carrying that many months here. I mean, it looks like it's what, March of 2019 through June of 21 on this page. Why is that a reoccurring cost every month?
This statement is inception to date totals. So as you go
Okay, that's
down,
a cumulative
yeah,
then? Okay.
exactly.
And then, are you applying the 50% penalty to that column?
No,
Okay. And you already indicated your central tank battery costs, the surface equipment, you're not charging that 50%, right?
that's correct.
What's the procedure that Whiting has to pay working interest revenues as far as timeliness? Do you try to get it out within 60 days, or how often do they get their revenue?
After payout, is that what you're referring to,
No,
or just in
well,
general?
Just in general.
We pay our working interest owners same as royalty owners, so we receive oil 30 days after the sale date, and we disperse that month, and gas would be 60 days out.
And as far as the revenue statements, are they sent out to all unleased mineral interest owners monthly, quarterly, ever?
They are sent out to all owners who receive payment in the month that they receive payment.
Okay, but I'm talking about unleased mineral interest owners that aren't participating though. So you're automatically deducting their amount. They would still owe money. They were not getting any revenue per se because you're subtracting that from their costs.
Yeah, if the well has not paid out yet, they would not receive monthly revenue statements until the well is paid out on their working interest portion. Their royalty portion, they would receive the statements.
Yeah, they would receive a royalty statement, but not a revenue statement for the well. I mean, you're just talking royalties.
Yeah, I'm sorry, the terminology must be different. So when I look at a royalty statement, we consider those a revenue and a royalty statement to be one and the same.
Okay. And once the well has paid out, do you send out a statement showing payout by month, or what does it include?
Typically, if an owner requests a payout statement, then we will provide the statements to them upon request.
Okay.
Once a well pays out, then we notify our division order department, and the owners will be added to the decks to start receiving payment.
And so the payout statement, like Exhibit 3, would not be sent out to any of those parties unless they ask for it.
That's correct.
Okay. And what happens thereafter? Are they sent anything besides a check if the well is paid out, or only if they're requesting it?
At this point, we provide it if it's requested.
And you talked, a fair amount about post-production costs. Can you identify any of the post-production costs you're talking about?
I know a few off the top of my head that One Oak deducts. There's a fuel charge.
The post-production costs that you're talking about, are they all associated with the gas?
It's all processing
Or are
fees.
there any post-production costs associated with the oil?
No, not that I'm aware of.
I recall that there were widespread contract changes from gas processors a few years back, where they used to have contracts with the producers that was a percent of proceeds that they would pay the operator. And then price of gas dropped, and many of the gas processors looked at their contracts and said, well, I can change those. So they went with charging for processing and gathering and compression versus giving them a percent of proceeds. Is that what has happened to One Oak contracts? Are you?
I'm not familiar with the contract specifically, but I know from looking at the statements that these are not the POP. They do not fall under the POP contracts that you're describing.
Okay, the percent
They
of
have,
proceeds.
yeah, they actually have the fees listed out.
And is this reoccurring throughout the entire Banks field, that you're seeing that those costs were increased on all wells?
I don't know for sure because I hadn't noticed. I haven't analyzed the cost specifically percentage-wise.
Okay, thank you.
Any further questions from commission staff? Seeing none, Mr. Mann, did you have any redirect or?
No, Mr. Examiner.
Okay. And I guess with that, we can go to closing statements. Mr. Hagan, I guess we'll let you have the first word, and we'll close out with Mr. Mann.
In closing, I'd like to summarize some of the arguments that I made and go over once again the requests that I'm making of the Industrial Commission. As a result of the statute that allows the NDIC to force pool minerals, I think it also gives the NDIC oversight authority over the results of that force pooling. I'd like to get some clarity from the NDIC on how far your authority goes on some of these issues. Do you have the authority to require them to pay unpaid royalties, for example? Do you have the authority to require them to make a proper payout? Do you have the authority to require all these things I've listed in Exhibit D1? There's a lot of things that came up during the process of discovery on this, where Whiting just says, well, they don't have the authority to do this, as if that settles it, but they never quote case law or give any history on that. It's an allegation that doesn't appear to have any backing on it. So the question, I think, is the bottom line is the NDIC going to enforce the statutes as they're written? What do they do or do not have authority over? And it's the NDIC statute, and I think you have the jurisdiction to make determinations on this. And I'm not asking for dollar judgments here. I'm asking for a proper accounting on these wells. I want to make sure that they have been that the payouts have been calculated correctly, and that the missing revenues have been recovered to the greatest extent possible. And to get the NDIC on record with some of this stuff, so that people in the future will know what to expect from a hearing like this. And the last thing I'd like to make another request of the commission. I'd like to do an audit on these wells. I would like you to audit the wells and make your own determination of whether the costs were proper and allowed, and make a determination as to whether the payout schedules are correct. I think Whiting has argued that this is matters for the court to decide, and I think the NDIC has a lot more say in this than what Whiting believes. They want you to give up your authority to do some of these regulations make no rulings and then let it go to court. And if that's what you decide, then that's, so be it. That's the way it is. We'll carry on. But it would be helpful, though, if the NDIC would clarify in orders or rulings that come from this hearing what their authority is on these issues, what their stance is. And that's all I have in closing.
Thank you for your argument, Mr. Hagan. Mr. Mann.
Thank you, Mr. Examiner. I covered primarily everything I wanted to up front with my opening, but, I mean, you've heard the testimony of Ms. Stevens, and applying North Dakota law, properly interpreting it, it's apparent that there aren't payout issues. The payout was calculated properly. Mr. Hagan's, what he refers to as his royalty burden, that was properly attributed, properly handled in accordance with North Dakota law, but also industry standard, as Ms. Stevens testified to. There are no missing revenues. To the extent there were issues on the reclass, I mean, those were straightened out by Whiting, and an audit, forcing an audit. I mean, it's not necessary. It's not necessary, and two, it's not really appropriate under the law in this situation. So with that, I guess we would just, request that the case be dismissed. So.
Thank you for your arguments today, Mr. Mann. And that will conclude the hearing in case number 29290.